in BloombergQuint. Now, you will recall that about a month or so ago, Cyrus Mistry and the Mistry family and the Shapoorji Pallonji Group, also known as the SP Group, made a fairly startling announcement saying that they were now ready to separate from Tata Sons. The Mistry family holds approximately 18.37% in Tata Sons, which is the holding company of the Tata Group. And the Mistry family is a minority shareholder in Tata Sons, but it's also the second largest shareholder in Tata Sons, the largest being Tata Trusts. As you know, for 4 years now, the Tatas and the Mistrys have been involved in a long legal battle ever since Cyrus Mistry was very suddenly ousted as chairman of Tata Sons. So about a month ago, he said that he was now keen to separate from Tata Sons. And today, we're told that a plan for separation has been proposed by the Mistry family in the Supreme Court, where the legal battle between the two is currently pending. I'll tell you what the broad contours of the plan are. Essentially, they involve a share swap. What the Mistry family is saying is, instead of the Tatas having to buy out their 18.37% stake, which would involve a large outlay by the Tatas, they're proposing that the Tatas give them shares in their listed companies in a manner proportionate to the 18.37% stake that the Mistry family holds in Tata Sons. So what they're proposing is a selective reduction of their capital in Tata Sons, which means their 18.37% gets extinguished, and instead the Mistry family is given proportionate shareholding in the listed companies that Tata Sons has any shareholding in. And about the brand as well as the unlisted assets owned by Tata Sons, those could be settled either via shares again of listed companies or via cash. These are the broad proposals that the Mistry family has put forward. And to discuss them and to discuss the legal basis for these proposals, I have two renowned lawyers with me, Tushad and Rajat Sethi. Welcome to both of you. I'm going to start, Mr. Cooper, by asking you on the legal framework on the basis of which the Mistry family has proposed this separation plan. The best I know is that the Supreme Court has currently ordered a status quo on both sides in this case, which is to say that Tata Sons cannot use Article 75 of the Articles of Tata Sons to squeeze out the Mistry family. Equally, more recently, the Supreme Court stayed any efforts by the Mistry family to pledge their shares in Tata Sons. The Supreme Court has not heard the case of oppression and mismanagement. That case, the Mistry family lost at the NCLT level and then won at the NCLAT level. What is the legal framework for a separation proposal of this nature?
Menaka, at any stage of any court proceeding, it is always open to the parties to settle or compromise the dispute. At the last hearing, it is my understanding that the SP group suggested that they were willing to put an end to the proceedings by having a clean break from the Tatas. No questions then would be left of their allegations of oppression and mismanagement, and all disputes could be put to a complete close. This proposal was prima facie accepted by the Tatas to the extent they said yes, they were willing to consider that proposal. Of course, the next question which would arise that for that proposal to be implemented, there would have to be a valuation of the shares and a payout of the quantum of valuation, which would ultimately be arrived at. Now, how was this valuation to be effected? Obviously, the two groups are going to be at variance over what the valuation should be. So the SP group, in order to clarify their view on what could be a reasonable mode of valuation, have come up with this proposal. Now, there are two factors to be borne in mind when the SP group have come up with this proposal. According to the SP group, their stake should be valued at about 175,000 crores, which is a massive amount. Frankly, I really don't see how the Tata group is going to buy out the stake. A, because for Tatas to put up the money themselves, it would be a huge drain on their other resources. B, a third party coming in to acquire a stake in this by buying over the SP group stake would be very difficult to find. If the argument is that the Mistrys with their 18% shareholding have no real say in the running of the affairs of the company, obviously another stakeholder who comes in is going to have equally little chance of success. In terms of an economic investment, which many sovereign funds, pension funds, etc., may be willing to put in without having any say in management, the returns from the Tata Sons shares, with the exception of TCS, are not something which would really enthuse any investor put up this kind of money. So how is it really going to be implemented? Now, that is really going to be a difficult question. So the SP group have come up with what they feel is a winning idea. I can see the Tata group coming up with many objections, and I'll come to that a little later. But obviously, as far as the SP group is concerned, their contention is that this is totally fair. We are saying that if the Tata Sons holds listed shares in listed companies, give us a pro rata distribution of those listed shares, and we walk out. So far as the unlisted shares are concerned, brand value is concerned, we get that value, and you pay us in cash. Now, how will this payment even be made? The major holder or the major investment of Tata Sons is in TCS. That's the crown in Tata's empire. In TCS, unfortunately, the shareholding of Tata Sons would, if divided in the manner in which the SP group is suggesting, result in the SP group holding more than a 10% stake. And I think this may well prove to be a sticking point for the Tatas to accept this proposal, because the whole idea is to put an end to all relationship between the Tata group and the SP group. And if they are to continue holding a 10% stake in the most valued company of the Tata group, Tatas will definitely put up a reluctance to accept such a proposal on this footing. And unless TCS is given to the SP group, it would be impossible to compensate, because the shareholding of TCS is itself the largest amount. So I find that implementation of the SP group proposal, although it may be a fair and reasonable proposal prima facie, or in fact, forget the fairness, it is the only practical solution, there will still be a sticking ground on the fact that they will say, we will not value it on this basis, and we will not implement it by giving you the shares of TCS. But absent giving the shares of TCS, it is very difficult to find how there will be a settlement. Another potential hurdle which the Tatas may raise, according to me, would be that apart from TCS, you're also giving substantial stakes, minority stakes, less than 10%, in various Tata companies. Now, it is possible that the SP group really wants this because it wants to liquidate its stakes and realize the cash. In listed companies, it has got an easy liquidation route. So maybe that's the reason why the SP group is keen on these shares. But should they sell these stakes as a block sale to another strategic investor, another rival of the Tata group in various enterprises which the Tatas are engaged in, that could again prove to be somewhat against the interests of the Tatas. Now, I don't know how Tatas are going to perceive this. Tatas have not reacted to the proposal. But I find that these are objections which the Tatas may face. The question then would arise, what then is the option? What then is the other alternative? And one may say that's the $1 million question or the 175,000 crore question.
But before you get to answering that, Mr. Cooper, let me take some of the points you've made and my original question to Rajat as well. Rajat, first a slightly technical question, right? Mr. Cooper pointed out that an out-of-court settlement at any point in time can be arrived at, in a situation like this or any other such similar situation. I just have one very technical question. The SP group has said that they are suggesting this kind of proposal under Section 242 of the Companies Act. Now, if I understand correctly, that is the section under which the tribunal has fairly wide powers to suggest or to make an order if it finds oppression and mismanagement in a company, but it does find that shutting down or winding down that company is not an appropriate solution, and therefore it then recommends or orders another solution. Now, to be fair, at this point, the Supreme Court has not even heard the oppression and mismanagement case. So to ask the Supreme Court under Section 242 to try and make such an order, would that work? Or is this a suggestion that the Supreme Court send it back to the NCLAT, which did find oppression and mismanagement, and ask the NCLAT then consider this kind of a plan in its order?
Yeah, so like you said, Menaka, it seems to be a proposal from the SP group at this stage. It's predicated, obviously, the way they have sought this particular relief. It assumes that there is oppression and mismanagement. But ultimately, the court has indicated that it would be open to the parties settling the matter. And at this point of time, I think the Tatas will obviously need to agree to whatever a settlement will be a two-way process.
Right.
So it's open to the SP group to propose something, and it is open to the Tata group to react to it. It's unlikely that the Supreme Court at this stage will, it seems to me at least, without having been party to the court proceedings in any way, that the Supreme Court will send the matter back to the NCLAT at this stage.
So Rajat, I'm sorry to interrupt. Sorry to interrupt you there, but I'm just trying to understand the mechanics of this. So if let's assume for a moment, hypothetically speaking, the Tatas do, despite all the potential objections that Mr. Cooper has spoken of, they do accept a proposal of this thing, right? How would it get effected? Because it would have to get, and this is a complex share swap that's being asked for. How would it get effected?
So it's unlikely that the Supreme Court will make a direction on this basis without the Tata's consent to it. What is being explored at this stage, Menaka, like you said right at the outset, is there has been no hearing before the Supreme Court.
Right, but let's assume that the Tatas do consent. Even if they do consent to it, Rajat,
sure.
If they agree, if they say the separation plan works for us, the nitty-gritties of how many shares, whatever, we'll figure that out.
Yeah.
How does that get implemented legally? Under what basis? What is the law provision? Which section are we looking at that something like this gets actually implemented?
So then, if both parties agree to it, then it could be possibly the relief has been sought, Menaka, under Section 242, like you said.
Right.
What is being proposed is a reduction of capital at the Tata Sons level, and in exchange for that extinguishment of capital, for the SP group to receive shares in the Tata listed entities. So that there is a provision for reduction of capital under the Companies Act, which is an application under Section 66 of the Act, which provides for a situation where a scheme can be presented for reduction of capital. And in exchange for reduction of capital, either you could receive cash or you could receive shares in another company. There is a procedure for it. If a direction is sought to be made under Section 242, then probably there would need to be some elements of that procedure which need to be followed, because any such reduction of capital will also require consent of creditors at Tata Sons level. So to the extent that there are creditors at Tata Sons.
If I understand that in simple terms, what you're saying is that the court would order, the tribunal would order, under 242, the creation of some such scheme, which then allows for the implementation of a share swap. Is that what you're saying? Correct.
Mr. Cooper, it seems that.
Sorry, please go ahead, Rajat.
Just one concluding thought on that. It seems that is the way the SP group has also presented it, based on whatever reports are available. They have said this is a scheme for separation. And the scheme is basically a scheme for reduction of capital in exchange for shares in the Tata listed entities. And they have said that under Section 242, the court has wide powers to provide for such a scheme of separation. So that's their plea before the court.
Mr. Cooper, just on the mechanics of it, narrow. You think that's how it would work? That if the Tatas were to agree as well, completely hypothetically, right? Then the Supreme Court or the NCLAT, wherever this is supposed to actually go to, would then make an order and ask for a scheme of this nature to be implemented?
Yeah, actually, there are two aspects to the application made by the SP group. One is, as you rightly said, if there is a settlement, and a settlement necessarily contemplates the consent of the other party. then in that event, the parties would themselves agree on the mechanics of working this out. They would go with a consent order to the Supreme Court. Everything would be over. Sometimes the Supreme Court has to nudge the parties towards a settlement. Sometimes the parties say we are agreeable to this division, but how to work it out, we leave it to the court. So proposal of SP could be a suggestion to the court that why don't you direct this kind of an implementation. The second is that assuming there is no settlement even between the parties, then the SP group puts this application forward saying that, look, we have succeeded in the NCLAT. We are therefore, it has been held that there has been oppression and mismanagement. Now there has to be an end to this oppression and mismanagement. And one way of putting an end to it is to have this division order. So it may be, in a sense, their argument that if the Supreme Court upholds the NCLAT order, then this is the mode in which the oppression and mismanagement could be put an end to. So you are right in saying that maybe at the moment it is premature because the matter has not proceeded to trial. But obviously, as and when it proceeds to trial, you're not going to keep having truncated hearings. So whatever Tata wants to put down as it stands, it's putting on record. So the application may be considered in that light also. So it may not be necessarily only on the basis that a settlement would be ultimately effected. But even if a settlement is not effected and the matter goes to a trial by the Supreme Court or the appellate hearing in the Supreme Court, they're asking the Supreme Court that you can do so. To your question as to whether it would go back to the NCLAT, I believe that is unlikely. The Supreme Court is now going to decide the question. If there is oppression and mismanagement, it wants to put an end to it. And the powers of the Supreme Court would be coextensive with the powers of the NCLAT to put an end to it in any manner they wished. They also have a power in any event to pass any order to do complete justice between parties. So they could also exercise those powers and put an end to these disputes.
But for that, the Supreme Court still has to find oppression and mismanagement, right, Mr. Cooper?
Of course, that is why I said that therefore, if a settlement is bipartite, the parties have to consent to it. If parties don't consent to it, it goes to trial. And if it goes to trial, the SP group says, if we are successful in upholding the NCLAT order, then please do complete justice by this method. The Tatas, if they don't agree, are going to contend there is no oppression and mismanagement, in which event they succeed in the appeal and the NCLAT order is set aside and the NCLT's order stands confirmed.
So you brought me to my second question, which I'm going to first put to Rajat and then come back to you. Rajat, without even getting into the merits of this separation, why would the Tata Group even consider this at this point? Wouldn't they rather wait to see what the Supreme Court has to say on oppression and mismanagement? Right now, we're one each, right? Each one has one at one level of the judicial system. They might just wait and say, hey, look, we're happy to wait 2-3 years. Nothing's changing for us. We'll wait till the Supreme Court hears the matter, till the Supreme Court decides. If the Supreme Court says there is oppression and mismanagement, then maybe we'll consider this separation plan. Why? There is absolutely nothing legal that stops them from waiting till this matter plays out in the Supreme Court. Have I understood that correctly?
Yes, there's nothing stopping them from doing that. But I think based on what transpired at the previous hearing, it seems that they are also keen to put an end to this. And while the Tata Group may not obviously like many aspects of this proposal, they would still, it's possible that if they are inclined to put an end to it, they may have some counter proposals also. And equally, it is possible that in the last few weeks, Menaka, after the previous hearing, there have been discussions between the two groups. So I don't know how that plays out into this proposal. Like you said at the beginning of the program, we do not have full visibility on what's going on in the background. But certainly based on this proposal, what one can say is that, as Mr. Cooper also pointed out, you are essentially transporting the problem from Tata Sons to the listed entities, which can possibly be scope for greater acrimony in the future. So you are pushing the can down the road perhaps, and leaving scope for issues later. So that may well be an important factor in any resolution, where you look for something which severs their relationship rather than leaving scope for bitterness at a later date.
Yeah, and I'm going to come to the merits of the proposal in just a bit. But I do want to sort of make just one very brief point clear. I was not in the hearings, but I do hear from lawyers that the Tata Group has made actually no concrete expression of desire to settle this as yet. There have been past instances where the Tata Group has offered to buy out the Mistry's 18.37% stake, and there was a hearing in which a remark was made where there was the suggestion that if you need money, because the Mistry family was trying to pledge these shares to raise money because many of their companies currently need it, there was the suggestion made by some of the Tata councils that if you need money, you could sell your shares to us. But I have not yet seen from the Tata end a serious proposal to actually achieve any kind of settlement. So far, we've only seen two statements, Mr. Cooper, from the Mistry family. The first was about a month ago when they said separation is probably the best solution. And now today's statement, which sort of lays out the contours. So I come back to you with a question that is both a negotiating skills question and a legal question. Why would the Tata Group not just wait to hear it out or play it out in the Supreme Court before having to decide anything one way or the other?
Menaka, you hit the nail on the head. It is essentially a negotiation tactic. The grievance of the SP group was that, look, we are trying to pledge our shares. Look at the Tatas, they're trying to strangle us. Their conduct is even more oppressive. They don't even want to let us pledge our shares. We can't raise finances. We can't carry on our businesses. This is one more indication of the acts of oppression which they're seeking to perpetrate. So what do the Tatas then come out and say? That, look, what are you talking about? If money is the question, we are willing to buy out the shares. Now, this is a mere offer. There are no contours to that offer, nothing. So the SP group says, well, if you're really serious about that offer, here we are. We are saying we are willing to accept it and have a clean break from you, buy over our shareholding and let us get out. But our valuation is 175,000 crores. How are you going to settle that? So we come up with, don't tell us that we can't raise 175,000 crores. We are giving you a viable proposal in which you can pay us the 175,000 crores. This is SP's attitude. You're absolutely right. Why would Tatas agree? This has been, I would say the Tatas have been driven to say that because of the fact that SP were making this grievance. The Tatas also know that the SPs need the finance today. So it may be a negotiating ploy on their part to say that, all right, you want to settle, you forget about your 175,000 crore claim, you come down to something far more reasonable, and we close the chapter today. Because the more we delay, the more your other projects may be getting affected. Now, I have no idea of the financials of the SP group, how keen they are for the money. This is a bit of poker from both sides. Who stares down the other more probably may succeed on that. But you're right, Tatas are in no hurry, because the faster the Tatas come out with the acceptance of the proposal, the sooner they have to give the money. And I don't think that they are in any hurry to do that. So you're right, it will ultimately have to be a nudge, a push from the Supreme Court for the Tatas to budge. The second aspect was that why would Tatas agree to this proposal at all till there is a decision of oppression which is held against them? But the question itself contains the answer. Because if the Supreme Court holds that the Tatas are guilty of oppression and mismanagement, and particularly on the mismanagement aspects, it would be a strong reputational blow to the House of Tatas, which hitherto has enjoyed a rather enviable reputation. So, I mean, I'm not saying there is, but one never knows how a court will proceed. And if a court comes to the conclusion that yes, the NCLAT order is correct, yes, there were acts of more than oppression, mismanagement, that would affect the Tatas seriously. And I think to preempt such a finding from coming, because then once the finding comes, then the consequences follow. And it's true that before the final judgment comes, they would say, yes, we are agreeable. But as you know, this kind of a case is being reported every single time there is a hearing. The press is picking up on every single observation which is made by the court. And the Tatas may not want a situation to be reached where any adverse comments are passed, at least on the mismanagement aspects of the case. And also, I think they ultimately feel, how long will this go on? They're going to constantly have these guys sitting like hawks, looking down their throat for each and every act which they do. They may also want to put an end to it. So that may be another motivating factor for the Tatas to put an end to the dispute.
So let's assume that there are some incentives for the Tatas, though I believe, or I would think, that they are in an very strong negotiating position right now, because it is the SP group that needs the money.
Absolutely.
That sought to leverage their shares were not able to, currently need to pay back several lenders, and therefore are in a position where they desire a solution far more than the Tatas. The Tatas seem to have more weighting power on their ends. But let's assume, for reputation's sake, to put a close to this chapter, the Tatas were to agree to some sort of settlement. And that settlement did not involve getting a third party to buy out their stake, because we don't know how that would work out. But that settlement somewhere came close to what the SP group has suggested today, which is that you take our shares, you extinguish them, and in return, you give us shares of listed companies. The first sticking point there, as you've pointed out and Rajat has pointed out, would be the 1,75,000 crore rupee valuation. Clearly, the Tatas will not agree to that, given that Tata Sons is a holding company. They will try and put forward all kinds of arguments on holding company discounts, etc., etc. So I would think that would be the first set of negotiations. The second set would be the hesitation to part with even a single share of TCS, because like you pointed out, that's the golden goose in the group. And that is the goose right now that's also funding all of Tata Sons' capital requirements through its dividend payments. So do you see that there would have to be major rework in this plan for it to be acceptable to the Tatas?
Look, as far as that is exactly what I told you was the 175,000 crore question. Because forget 175,000 crores. You're right. The SP group may be pegging their value at 175. I'll take it that huge discount, 50% discount, comes down to 80,000 crores. Even 80,000 crores, how is it going to be paid? It has to come from somewhere. And the only way in which it can come from, or for which Tata Sons can realize, is by selling its own stake in the market and paying off this 80,000 crores, or giving shares of equivalent value to the SP group. Now, it may be that they may transfer it to the SP group. It's possible that they may agree to some kind of a covenant that the SP group would liquidate that stake by sales in the open market over a period of time, so that after a period of 3 years or 4 years or whatever it is, they cease to be shareholders of the company. So that aspect of them continuing to cohabit and live with the Tatas may come to an end. There may be further refinements to this proposal. There may be, as you rightly said, negotiations on the valuation, and possibly in return for the SP group making concessions on the valuation, substantial concessions on the valuation. It's possible that the Tatas may say, all right, then in that event, we'll do ABC with sufficient safeguards. They will say that you will not interfere in management, you will not raise any such disputes, etc. I don't know. That is for legal team, accountants, etc. to sit together and come up with some proposals. But absent, where is the money going to come from? There is no other way for the money to come from. And I think SP Group on that footing has canvassed this proposal. If the Tatas find some means, some good sovereign fund which wants to back them for other reasons, because there are other projects which they may be contemplating, great. They may then be having the money and the liquidity to pay off these persons. But otherwise, at the moment, I don't see any other proposal. And that's a fact from the fact that Tatas themselves have not come up with any other proposal.
I wonder what
statement that they're willing to buy.
I wonder what message that sends out. That so far the Tata Group in the last month or so, ever since the Mistry family has proposed separating from Tata Sons, has really said nothing in public whatsoever, right? Rajat, how do you view the specific merits of this proposal that the SP Group has put up? We've discussed some of them. What are your thoughts on whether it will work or not work, assuming that the Tatas are willing to come to the negotiating table and consider this?
I think at its core, Menaka, it's a principle that is helpful. At its core, it's a principle that you give up shares in Tata Sons and get shares in the listed company. So Tatas don't have to pay cash for those shares. So there are obviously some misgivings, or there will be several misgivings rather, from the Tata group side. And possibly one will have to look at this structure in combination with some other structure. It could well be that So it could well be that you extinguish over a period of time, and shares are given in listed companies over a period of time, or you combine this structure with a sale of the shares which the SP group will receive in the listed entities. So, for example, if they're receiving shares in the listed entities, then some kind of covenant, as Mr. Cooper said, to sell the shares in the listed companies. What that will do is it deals with the issue that the Tata Group may be facing right now, that they don't get investors in Tata Sons. On the basis that there is no liquidity, Tata Sons will have to provide some plan for a future listing, etc., which the Tata Group may not be open to considering. Whereas if investors have the opportunity to invest in a swath of Tata listed companies or a bouquet of them, then that may well be a possible option. I'm just, thinking out aloud here, but it may be a more attractive option than making an investment in a holding company. So obviously, all of these options and structures in combination, I think this presents an idea. If it has not been discussed before with the Tata Sons management, then it presents some further element which can be used for as a reference for discussions.
Okay, fair enough. So these are the benefits that even the SP Group has cited, right, in its legal documents and in its statement, that this kind of pro rata separation of both assets and liabilities is fair, it's equitable, it reduces any kind of dispute on valuations, because at least one end of the valuation game, which is the listed company stocks, those have, sort of well-determined market prices to them. And it also reduces the cash burden or the cash settlement burden on the Tata front, because this is a largely non-cash settlement situation. We don't know which way this will go, but both of you are veteran lawyers, so I'm going to ask you both to put yourselves in the shoes of lawyers of both these sides and tell me how you think this will proceed. Rajat, if you were on the Tata end, what would you do? Would you just wait it out and see how it plays? Or would you actually consider something of this nature with tweaks?
I think obviously this proposal has a lot of, as we discussed, Menaka, it has several causes for concern for the Tata Group. I would have been working already on, some possible structures to address this issue, as I expect that their legal teams and their accounting teams have been working. This is certainly one aspect which can be used as part of the overall exit for the SP group. That the concept being that in exchange for shares at the holding company, you get shares in the listed company. What the contours of that transaction will be, that can, require more detail. Holding company discounts, there are liabilities at the Tata Sons level, there are preference shares. So a simplistic solution that 18% of Tata Sons translates into 13% of TCS does not make sense, even without looking at the Tata Sons balance sheet.
Yeah.
Having said that, I think there are some elements of it which could be developed further in an ultimate resolution of this matter. Because ultimately there will have to be some resolution. It can sort of go back and forth, and there can be further negotiations and parties can play some poker, but ultimately there will have to be some resolution.
Mr. Cooper, if you were lawyering for the Tatas, what would you do?
Okay. As the lawyer for Tatas, one, as you have very rightly pointed out, not being a lawyer, but still you have rightly pointed out, that this is ultimately some kind of a negotiation play. How far do you take this negotiation play will be the question. I don't even think the SP group really expects that the Tatas would say, yes, this is fine, 175,000 crores, we'll go out. So obviously this is like an opening salvo which the SP group have fired. They are waiting now to see what counter the Tata group comes up with. Again, as you have rightly said, it is in Tata group's interest to wait it out. So they are waiting also to push and see till what stage the SP group becomes really keen to have its settlement closed out, signed, sealed, and delivered. When they feel that the SP group is growing more anxious for a settlement, that is when they come in and make an offer which they feel would be at a substantial discount to what the SP group is asking for. Obviously, if they make too lowball an offer, the SP group is going to reject it. I mean, ultimately, when your back is to the wall, you have no option but to fight. So the SP group will fight. If the SP group is successful, as it was in the NCLAT, then it is the Tata group's back which will be to the wall, and they will want to close out the issue. So ultimately, you can pull the string to a certain extent, but you can't let it break. So at what point that comes, that is a matter of negotiation skill, negotiation strategy. I agree with Rajat when he says that the principle will have to be that shares will have to be given because money will not be easily realizable. The question is how much. And that is why, again, I came back to the thing. It is the 175,000 crore question. Whether it will turn into an 80,000 crore question, or 50,000 crore question, I don't know. That is something which will depend on the negotiating skills of both sides and timing. If the matter gets indefinitely shunted off in the Supreme Court, I really don't know what will happen because it would probably drive the SP group closer to a more reduced valuation. If the hearing is to take place sooner, I think the Tata group may have a more realistic valuation on things. I really don't know how this will ultimately play out.
But Mr. Cooper and Rajat, it's been a year since this matter reached the Supreme Court and not a hearing has happened. Whatever hearings that have happened so far have not been on the merits of the oppression and mismanagement case. They've been simply on the status quo aspects of either Article 75, which is an article that gives the Tata Sons shareholders the opportunity to squeeze out Mistry, or in this case, the pledge of shares. Not a single hearing has happened on the actual merits of oppression and mismanagement. So, like you said, we don't know how long it could take in the Supreme Court, and time will determine who becomes more anxious than the other, and therefore which way the deal goes, right?
Two quick answers. One is that it is not abnormal for the hearing not to have taken place in the Supreme Court. Time does fly when one wants a hearing made urgently. But where there is an urgency which the SP group can push is that they wanted to pledge their shares. And they said, this pledge has been held up. Forget the overall settlement, forget the decision as to whether there has been oppression or mismanagement. Why are we being prevented from pledging our shares, which we had earlier done? So this is the trigger in which they can push for an early hearing of that issue. And if they can pledge the shares, and the Supreme Court allows them to pledge the shares, then the pendulum switches back to the SP group, then they are in no hurry to get a full closure of the matter. So that is the additional fact as to why it's not been heard. Also, the COVID situation is there. So there's some kind of justification why courts are not functioning at full capacity and full speed. So that has also delayed matters. But on the pledge aspect, that is the aspect on which the SP group can push for an earlier hearing of that issue.
Okay, you said 2 points. That was the first point. Was there another last point that you wanted to make before I close this down?
The pandemic. The first point was that...
okay, the second point was the pandemic.
There's nothing abnormal in these long periods of time. Courts take their time to hear matters. Ultimately, because the stakes may be huge, but ultimately they're just two parties. There are many other parties which have many important grievances for themselves. So there's nothing so extraordinary in this case except the huge stakes involved and the personalities involved.
Point well taken. Rajat, any quick last words on this before I close it out?
I think, Menaka, it's been a fairly quick resolution, as Mr. Cooper said, from 2016 to 2020, we are before the Supreme Court.
It's been 4 years.
You compare, it was towards the end of 2016. In the middle of that, we've also had a year where, once in a century year. Yeah. So I think it's probably the courts have acted faster than one has seen in other oppression and mismanagement cases. Obviously, this is also a unique case which affects control and management over various leading listed companies in India and one of the largest business empires in India. So it has received attention and I think arguments have been heard in this matter in both the NCLT and the NCLAT in priority over thousands of other cases. So I think it has received more than its share of attention.
Okay, point well taken.
And I think it will be the same in the Supreme Court as well. The trigger, possibly, as Mr. Cooper said, is on the pledge of shares, and if they are able to leverage that point, then it may well be that they are able to further expedite the hearing before the Supreme Court in relation to a potential settlement.
All right, gentlemen, thank you so much for your views. Like both of you have pointed out, while there are many legalities to this matter, and there is the commercial aspect of how a settlement is carved out, valuations, etc., this is also at the end of the day, an incredible negotiating game to be watched very, very closely. Thank you both for joining us this evening. I'm sure we will have many more occasions to discuss the twists and turns in the Tata Mistry case in the days to come. Thanks to all of you who've been watching BloombergQuint.
Thank you.